Welcome to High Stakes Criminal Defense Podcast.
Welcome to the High Stakes Criminal Defense Podcast with Attorney Jeremy Babich of Levine, Flier and Flier in California. When freedom, reputation, and a lifetime of hard work are on the line, the person you choose to stand beside you in court is one of the most important decisions you will ever make. Jeremy focuses on high-exposure criminal cases representing clients in serious felony and complex cases where strategy, preparation, and courtroom performance matter the most. I'm LeAnn Lyon, and today we are talking about how murder charges are defended and how the defense dissects the prosecution's theory. Hello, Jeremy. It's good to see you again.
Hi, LeAnn. It's great to see you again, as always.
So, Jeremy, when somebody is charged with murder in California, what are you analyzing first as you begin to build the defense?
That's a very interesting question, and I think the beginning of how you approach a murder trial is crucial to how successful you are going to be in the long run. You have to figure out, first off, whether this is a self-defense case, a defense of others case, a misidentification case, whether your client has any alibis, and what the motive would be behind the murder. All of these factors are crucial, and you have to dissect each and every one of them and really go through them and try to see what you and your client can answer, what you and your client can figure out, and what the evidence shows. You obviously have to convince the jury that your client didn't do it, whether he was doing it out of self-defense, whether it wasn't even him. So all of those factors are crucial, and you have to get to that theory when you first begin and get on the case.
You recently secured an acquittal in the People versus Avery Bennett case in downtown Los Angeles. When you approached that case, what stood out to you early as you evaluated the prosecution's theory?
Yeah, so that case was extremely fascinating because for me, this was the first case I've ever seen where the prosecution built their theory on pretty much extensively and exclusively on circumstantial evidence. Their entire case was based on circumstantial evidence, whether it was shoes looking like shoes my client was wearing, clothes looking like clothes my client was wearing, the car that was seen near the crime scene looking like the car my client was driving at the time, my client being in the area of the shooting prior to the shooting, my client's phone being turned off around the time of the alleged crime occurring. And this was without a doubt where both sides agreed that it was first-degree murder. The main difference in this case was my side believed that they had the wrong guy, and the prosecution, through circumstantial evidence, believed that my client was the shooter. However, the thing that we stressed on, and I believe became very vital to us, was there was no motive. This was an intra-gang apparent shooting that the prosecution was trying to sell, that two people from the same gang had an animus towards one another. And they used old social media messages from about 7 months ago. And outside of that, there wasn't really any sufficient way for them to establish the motive for my client being the shooter and relied solely on circumstantial evidence.
The prosecution often presents a detailed timeline in murder cases, as I'm sure was the case there. So, how do you approach breaking down that timeline?
You really have to take it step by step, second by second, and really plan out what happened the day of the murder. Whether it's making sure what your client says, if he gets on the stand, falls and aligns with the evidence in the case. You have to, of course, as a defense attorney, talk to your client, try to come up with answers as to, for example, in Mr. Bennett's case, why he was in the area at the time, why his phone was turned off at a certain period of time. You have to be able to answer all of those questions because the jury is going to go back to that jury deliberation room and say, well, there's a lot of coincidences here. Does that equal beyond a reasonable doubt? I don't know, but the defense never provided me answers to certain questions that I have. And so that's something you have to make sure you do get across to them. And in this instance, we put Mr. Bennett on the stand and he testified. He walked up there to the witness stand, took an oath and testified. And the jury ultimately came in with an acquittal for him on all of the murder charges. And he is now out of custody back home. And this was a huge win for us. But you have to ultimately be able to really dissect the facts and really make sure that your client is aware of what the evidence shows.
So is intent or the theory of intent, is that the same as motive?
So, not necessarily. The intent is something that is necessary for murder. Like, you have to have the intent to murder someone. Sometimes that intent is shown by reckless disregard for human life. Like, let's say you go into a movie theater without intending to kill anyone, but you're shooting your gun like 10 times. That's where you have the reckless disregard for human life, and you can be found guilty of murder if one of those bullets hits someone and kills them. But motive is not a necessary element to be convicted of murder, but it is something that the judge will give as a jury instruction and something that the jury can consider when deliberating. And ultimately, it is very important, especially as a defense attorney, if the prosecution can't really show a motive, because that's a huge argument for you and the support of your case in terms of trying to get the jury to return a not guilty verdict is showing them that there was no motive in this case, as we did with Mr. Bennett.
So let's talk more about intent then, which is a critical element in many murder charges. How does the defense challenge the prosecution's theory of intent?
Well, I guess it's a case by case basis. Like, for example, if your theory is self defense, then ultimately that doesn't necessarily mean that the your client was trying to kill someone. However, they had a reasonable belief, and it's a reasonable person standard that their life was in danger. And as long as they used force that was reasonable to defend themselves, that's how you can start to attack the prosecution's theory. Also, whether if it's, for example, a defense of others, like you see someone getting attacked and you try to be a reasonable person and go and help them out. And then ultimately something happens where you accidentally push someone off of a person who was hurting someone else and they trip and fall into the street and get hit by a car. There's so many factors in murder cases that need to be considered. Or if it's a heat of passion, for example, a husband gets home from a long day of work and sees his partner having an affair. That's something that then a reasonable person would then claim a heat of passion defense, which led them to lose their mind and cause them to do something that ultimately they regret for the rest of their lives. But it also depends whether or not you can even attack their case as your client not even being there or a mistake of identity. For example, if there's no witnesses that can even identify your client, that's huge and important, and you have to stress that. And or if there's a mistake of identity, if, for example, the witness gets on the stand and identifies the wrong person or can't identify your client when they're on the stand. All of these factors are ways you can start attacking that mental intent.
Let's talk about witness testimony and how that can shape how jurors view the case. What are you looking for when evaluating key witnesses?
So it's very interesting, and it depends what kind of witness it is. Is it an expert witness or is it a civilian witness? Once you're in the expert realm, you have to ultimately understand, why is the prosecution calling this expert? Is it to establish the motive? Is it to establish location data? Is it to establish gunshot residue being on your client's hand when they did that test, the gunshot residue test? So you have to really evaluate what this witness is being called for. And then once you have a real good grasp of it, because as discovery and discovery laws in California, you are going to most likely be aware of that, of what that witness is going to say when they get on the stand. So you have to really already have an idea of what you want to attack, an idea of what you want to get out of that witness, an idea of how you can flip what that witness said and direct and use it to your advantage to support your theory of the case, to support your defense. And all of those factors are so crucial, especially when you have expert witnesses, because if it's very effective when you can use the prosecution's expert witness to essentially corroborate an important, crucial fact that supports your theory.
Yeah, I can see that. Well, in gunshot, gunpowder residue is a form of forensic evidence, and we know that that can carry a lot of weight. So, how does the defense evaluate and change that type of, or challenge, I should say, challenge that, probably not change, challenge that type of evidence?
That's interesting, and I guess it depends. Is it something that might have been found on the alleged victim too? Because in a murder case, there's a victim, someone's dead. So ultimately, if that victim had gunshot residue on his body part as well, that's something you can obviously look towards using as, oh, your client shot back at him in self-defense. And ultimately, it's crucial. But if it's in your like but if it's your client who has the gunshot residue on his body part, then you have to really develop why he was shooting a gun at that point. You have to really stress it. And it kind of then goes to you trying to figure out, is this a case where my client has to testify? Is this a case where the jury needs to hear from my client as to why he was shooting a gun and what actually happened? Ultimately, they're not going to hear from the victim since the victim isn't here anymore, but your client has an opportunity to get on the stand, to tell them what happened. And it's his side of the story that ultimately, if they believe, can give them just enough to vote that not guilty. And ultimately, in my opinion, if your client testifies, the jury is going to decide the case whether or not they believe your client once he takes the stand.
How important is early investigation by the defense team within murder cases?
I think it's extremely crucial because you have to be able to gather evidence, whether it's camera evidence, surveillance evidence from the crime scene. You have to be able to make sure that is saved, maintained, isn't overridden by other camera footage, because it happens all the time where there's businesses that have active cameras that could have caught something important at the crime scene, but they weren't preserved or they were missed in the investigation by the police or the detectives. And so it's up to you as soon as you get on the case to make sure that if there is camera surveillance footage that would support your theory or prove that it wasn't your client there, then you have to make sure you get that evidence, or at least write a preservation letter. Make sure that that evidence is saved so that the police are able to go get it afterwards. And you have to also be able to talk to key witnesses, whoever was there. Was there anyone who can corroborate your side of the story? Was there anyone that corroborate the fact that your client wasn't even there? All of these are very important, and you want to get to it, especially before the prosecutor or the detectives might be able to get to certain witnesses. And all of a sudden, their story isn't what it typically would have been if they were telling the truth, and or certain witnesses might then not want to testify because they don't want to be involved in something that involves murder. So it's very important for you as a defense attorney to get that investigation started as soon as possible.
There's so many factors that play into this, from jury selection to cross examination. How does presenting an alternative explanation change the way jurors view the prosecution's case?
I think you need to give the jury a reason to believe your side of the story, and also a logical, reasonable explanation to certain facts. You have to be able to give them that, because ultimately you break down a case and you kind of try to get in the mind of a jury, and you try to simplify it. You try to go in a murder case, for example, and say, why would Mr. Defendant kill the victim? You try to just answer that simple question. And if you can give the jury a reason to believe there was no reason for him to kill him, there was no motive, or, for example, the reason he did kill him was because his life was in danger and he was trying to just save himself, you have to be able to really drive that theory, facts, that theory supported by facts down to the jury, and make sure that they at least have a reason to vote not guilty. Because if you can't answer those simple questions that the jurors are going to ask themselves when they go back in that jury deliberation room, then you're doing your client a disservice.
We talked earlier about the case where you said it was pretty much all circumstantial evidence. So, how are you able to build a defense approach with reasonable doubt in that case?
So the key there became trying to show to the jury that, one, my client had no reason, no motive to kill the victim. Second, my client had a very reasonable and believable reason for being in the area of Pasadena in this instance. He was visiting his family to watch a playoff basketball game, and also give them a reasonable understanding as to why my client turned his phone off. He got into a huge argument with his wife on that day, which led him to turning his phone off because of issues. And so you give these jurors a rational understanding, and you try to really poke holes at the prosecution's theory that they're trying to just put together all these different facts based on circumstantial evidence, but there isn't an eyewitness that put my client there. There isn't an eyewitness that put my client's car there. There wasn't any camera footage that put my client there because the suspect was wearing a hoodie and you could not see his face. And his body did not look like our client's body in terms of height and weight. In addition, you then start poking holes that they thought the white SUV was similar to our client's car. And in fact, it was. But how many white SUVs are there out there? So you start poking all these holes in the prosecution's case, little by little, brick by brick. And that's where you ultimately just need one to be on your side, but you hope you get all 12 of them to really see that the prosecution did not prove their case beyond a reasonable doubt.
As we wrap up this episode, and as you are preparing for trial, how do you decide which parts of the prosecution's case to confront directly and which parts to reframe?
That's something that I guess depends on what the evidence shows. You really can't obviously go and give a laughable reason to the jury as to why certain evidence points a certain way. You have to sometimes concede. For example, in this case, my client was a gang member, and he didn't hide from that. He admitted that he was a gang member, and that's something that the jury saw in him, that he was a gang member, but that doesn't mean he killed someone. Just because you're a gang member doesn't mean you're guilty of murder. In addition, we gave them a rational explanation that my client was transitioning out of the gang life. He has a wife, 2 young kids. He had a great job that was paying him 6 figures. So he had no reason for this murder. But ultimately, you have to be able to give the jury and look them in the eye and say, you know what, my client admitted he was a gang member. He didn't hide from that. He didn't try to like make up a lie and say, oh, he just got those tattoos because he likes tattoos or he was buddies with some people in the gang. No, he admitted it outright. So certain evidence you have to admit. And you also have to have credibility with the jury. If you don't have credibility with the jury, then that's where your case is shot. You have to be able to look the jury in the eye, admit it. When the evidence is there to establish certain facts, you have to be really able to look the jury in the eye, be credible, and support your client and make sure that they believe, even if those facts are true, that doesn't necessarily equate to the facts leading to guilt beyond a reasonable doubt. It is ultimately an abiding conviction that you have to have as a juror to vote guilty. And that is where me as a criminal defense attorney, I have to be able to knock things down, put cracks in the prosecution's case. But ultimately, I don't want to look a jury in their eyes and say something to them that I believe is nonsense. And that's where the credibility is so vital and important in terms of you arguing a case to a jury and your client, if he does get on the stand, admitting certain facts, because that will go a long way to the jury then believing his or her story.
Well, thank you for this illuminating and authentic conversation. And to our audience, we want to thank you for listening to the High Stakes Criminal Defense Podcast. When your freedom and reputation are on the line, understanding how serious charges are defended can make all the difference. To learn more about Jeremy Babich and his approach to defending high stakes criminal cases, visit Levine, Flier and Flier.com. Be sure to like, subscribe to the show, and leave a review if you found this episode helpful. And we'll see you next time. Thank you, Jeremy.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.